During settlement discussions in a medical malpractice case, the defense attorney tells me that they need more time to evaluate your case. They need more time. They need a few more months before they can actually start negotiating, before the attorney is given authority to actually offer money. What does that mean, that he needs more time? What does he need more time for? Would you like to know the answers to those questions? Come join me for a walk around the lake as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You brought a lawsuit, a civil lawsuit against a doctor whom you believe was careless, causing you significant harm and injury. And now, for 2 years, the defense has refused to pay you a single dime. They have refused to negotiate. They have always taken the position that they did nothing wrong and that they will never offer a single dime. They will see us at trial. We proceeded through the litigation process, and now, as we are approaching trial is about a month away. Now I get a call from the defense attorney who says, listen, we'd like to start negotiating. And my client says to me, what were they waiting for? And in addition to that, the defense attorney had told me they need more time and they are going to ask the court to push the trial date back so they have sufficient time to actually conference your case to decide whether they are going to offer substantial money to try and settle your case before we actually go to trial. And you turn around and say, what do you mean they need more time? They've had 2 years to evaluate this case. They took all this time, they sat on their hands, they did nothing, and now as we're approaching trial, they want additional time. Why should we give them additional time? Why should we agree to that? And the response is, if they go ahead and ask the judge for additional time, because they are now seriously considering whether to resolve this case or at least to engage in settlement discussions, in all likelihood, the judge is going to give them additional time. Why? Because there is the possibility that they may be actually truly interested in settling this case before trial, and the judge is interested in trying to resolve these cases without the need for sending them out to trial. When a case goes out to trial, it means that another judge in the courthouse now gets involved in this particular case to try. Now that judge and all the resources associated with that courtroom are now taken up for a number of weeks while the judge is trying the case. And now he has to divert other cases to other available judges. So it takes up a huge amount of time and energy and resources, court resources, in order to try a case. If the court is able to try and resolve a case before ever getting to trial, that's what they will often try to do. So if the defense comes to them during a pretrial conference and say, listen, we want to go ahead and start negotiating, but we need more time to conference the case. Will you give us a couple of more months? In all likelihood, for the first or second time, I believe that the court will go ahead and give them that additional time. So now you ask the question, okay, so what is the purpose of having this additional time to conference this case? I'll tell you what the purpose is. The purpose is so that the attorney can now present our case, your case, to the insurance carrier. There are various layers that they have to go through, layers of authority, in order to determine, number one, whether they think they are at risk of going to trial. If they believe that they are at risk of going to trial, what does that mean? It means that there is a possibility that if they go to trial and a jury now goes ahead and reaches a verdict, that there is a substantial possibility that the jury will come back with a verdict against them. If they expect to get a verdict against them, now they have to evaluate what kind of damages they can expect a jury to give. Is it a substantial case? Are there substantial damages that a jury could latch onto? Is there an emotional component to it? Where is this case venued? Where is it taking place? What type of person is this that's bringing the lawsuit? Are they likable? Are they lovable? Do they have a compelling story? All of these things go into evaluating for the defense as well as for us whether or not it is worthwhile to take the risk of going to trial. And in case you don't know, no matter what type of case you have, no matter how great a case you believe you have, no matter how many great experts you have that are in your favor, that are coming to testify in your behalf, you never know what a jury will ultimately do. They could disregard your testimony. They could disregard your expert's testimony. They may not like your attorney. There could be many reasons why a jury comes in against you, despite the fact that you believe you have a great case, and your attorney believes you have a great case, and you have great experts, and all of that is wonderful. However, there is the great unknown, which is nobody on either side, and the judge, nobody knows exactly what a jury's going to do. So let's get back to the question I raised at the beginning of this video. Why do they need this additional time? And oftentimes, the reason why they need additional time is because the insurance carrier, the people that the attorney needs to present this case to, they only meet a number of times per year, or they might meet only once a month, or there may be a certain schedule in which they meet, and now he needs to get on that schedule in order to present your case, so that now, after meeting with them, he can get authority or get no authority on whether or not to go ahead and start negotiating. And if they tell him, yes, we give you authority to negotiate, they will often tell him, here's how much money you have, see if you can save us a few dollars. And that's when negotiations begin. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you want to see the beautiful lake. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.